Hello everyone and welcome to this session on the EU-US Privacy Shield. My name's Eleonor and I'm a lawyer at Fieldfisher in London, and with me on this webinar is my colleague. This is part of the Get Data Protection Fit series. This is part of Module 3, Cross-Border Issues. So we've taken you through standard contractual clauses, binding corporate rules projects, and now we're focusing on the EU-US Shield, what you need to know. So what's going to be the structure of this session? Well, firstly, we're going to talk about why did Privacy Shield get struck down by the Court of Justice of the European Union? And then we're going to discuss how this gets resolved and some of the issues around that. And then we're going to talk about why it makes sense at the moment to continue with Privacy Shield if you're Privacy Shield certified. So by the end of this session, you should be better able to explain what went wrong with Privacy Shield and why it makes sense to stick with it. Now I'm going to hand over to Alex to take you through why Privacy Shield got struck down.
Thank you, Eleanor. The Privacy Shield was struck down, of course, in the recent CJEU case of Schrems 2. We're not going to go into too much detail about the case itself because it's been widely covered, not least by this team in another excellent podcast on our YouTube channel and by our blog, which the details we'll put on the slide later. But it is important to just recap what the court's main findings were. They really were split into these three sections that you can see on the slide there. So firstly, that there is a primacy of US surveillance requests for access trumps the obligations under Privacy Shield. So organizations under Privacy Shield are US companies. Typically, they will be subject to US law. If the FBI or someone comes and knocks on their door with a legally binding warrant for data, they tend to give it to them, regardless of what Privacy Shield mechanisms may say. Secondly, of course, the main concern is around government surveillance. And in the States, there are a couple of different routes which the surveillance may take place. It could be under the FISA, Foreign Intelligence Surveillance Act, or an executive order, 12333. Both of which give the intelligence community quite wide powers to demand data from US providers. The Court of the EU thinks this is disproportionate as it's not limited to what's necessary. And although there are some limits on it, they were felt to be insufficient. And then finally, the ombudsperson mechanism, which was widely hailed as a great thing, a good part of Privacy Shield. There was some mechanism to complain to for EU citizens so they could complain about their data being misused. It was a bit held to be ineffective. So the ombudsperson themselves weren't even appointed until 2019 and it was a part-time job. There was a supporting board, the Privacy and Civil Liberties Oversight Board, which only had 2 of the 5 members for most of the time. And therefore it was felt that EU citizens didn't really have a proper redress there. They couldn't really use their fundamental rights for data that had been taken by surveillance agencies under the Privacy Shield. That should have been protected under Privacy Shield. Next slide, please, Eleanor. Okay, so now we'll look onto how this gets resolved, and you'll see we put a crystal ball up there, and that's just to indicate that a lot of this is, of course, us trying to hypothesize about what the possible resolution is. So firstly, does it need to be resolved? Well, we think, yes, it does. The flow of personal data is vital to world trade in the modern electronic era. It's calculated that the value of EU to US data flows approximately $71 trillion annually. That's trillion with a T. And the EU and US have a long-standing ties and closer to some of the other major powers that are currently emerging throughout the world. And then, of course, you can't talk about anything these days without talking about COVID. It's going to be the worst recession for probably 100 years, and trade will be vital to restart economies across the globe. Let's move on, please, Eleanor. So how are we going to resolve this? Well, firstly, the main likely option will be through talks. Both the European Commission and Department of Commerce, who were the parties that agreed the Privacy Shield, have indicated that talks are already underway to discuss a potential replacement, Privacy Shield 2 or a Safe Harbor 3. And some commentators have noted that actually there's a lot more common ground now than when they were started to debate Privacy Shield back in 2015. However, the European Commission has already announced that there's no quick fix. It may involve US legislative change, which we'll come to shortly. Okay, next slide, please, Eleanor. Now, of course, it is an election year this year in the US. It's hard to avoid that, and the election itself could have an outcome on the future of any other transatlantic arrangement. So current President Trump has not been a huge fan of Privacy Shields. There was an executive order in 2017. I did write a blog about it. It'll be on our blog if you search that, which appeared to remove some of the protections for EU citizens and derail the process. The European Parliament was not very happy with that order. The Trump administration has also pursued a very US-first policy and led to strained relations with some old alliances, such as those in the EU, NATO, and so on. Trump, of course, could win this election, in which case we may see more of the same. Alternatively, polling numbers at the moment are showing that Biden is just ahead. And if a Biden presidency were to follow, we feel it's more likely that Biden would seek to build bridges, restore some of the harmful relations that have happened in the last few years, try and improve some of the strained relations with the EU, and a new transatlantic data arrangement could be one way of doing that. Next slide, please, Eleanor. And so the question will be, is new legislation required? Well, the commentators in the early stage of the talks think yes. As I mentioned, the executive order and the FISA are the legislative framework which currently gives the intelligence community these vast, wide powers. So to undo that would require a legislative change to move it in a more restricted manner. The European Commission and European Parliament have both come out and said, any future framework will require legislative change on the states' behalf. The CJEU position is quite clear on what the Europeans feel. And recently, related to all this, of course, were the Snowden revelations, which brought into the public a lot of this surveillance for the first time. And a case just heard by the Circuit Court of Appeals in America decided that the NSA surveillance aspects of it, at least, were unlawful. This is still appealable to the Supreme Court, but it could be impetus for more legislation change as well. But of course, this is only our predictions of how this could get resolved. Nothing's been announced in public. And that's back to you, Eleanor. Eleanor, if you're talking, I can't hear you.
Sorry, I've unmuted myself. I didn't want to go on to the next stage here until we talked just briefly about the elephant in the room, as it were. And I think it's worth mentioning that the Court of Justice's reasoning was that when data gets sent abroad, you have to have essentially equivalent protections to those in the EU. But there's one really difficult aspect to that reasoning, I think, which is that the Court of Justice said that the national security provisions in the US were problematic because they didn't afford the rights which EU citizens expect when their data is being processed. But the irony there is that, in fact, the Court of Justice and the EU institutions are not allowed to look into how European countries process data in a national security context. So where the Court of Justice has said the US standards aren't good enough in the national security context for EU data, and the standard of protection is being compromised by those national security services in the US, in fact, they aren't even able to look at what's happening in the EU in terms of the EU's national security services. So in a sense, there is a lack of realism, I think, here with this judgment. And I think it's just worth pointing that out, that in fact, the standard that the EU is applying to others is not actually applying to itself. Right, so we move on now to part 3. Why does it make sense to stick with Privacy Shield? Well, firstly, Wilbur Ross, who's the Secretary of State for Commerce in the US, said that the fact that Privacy Shield is now invalid for data transfers does not relieve the participating organisations of their responsibilities under Privacy Shield. So if you are Privacy Shield certified, then you are expected to continue to comply with those requirements. And why is that? Well, it's partly because even if you were to leave, the legacy data that you received during your certification period, as it were, being Privacy Shield certified, you have to protect that data that you got while you were certified to essentially the same standards as set out in Privacy Shield. So you can't entirely leave it in any event. But also, we think, as Alex mentioned, that there is going to be a new Privacy Shield to Safe Harbor 3, whatever you call it, a new adequacy decision in favour of US companies who are certifying in the context of a new mechanism, a new improved Privacy Shield. So one of the reasons that it makes sense to stick with Privacy Shield is that it may be that you have a relatively seamless transfer from the current Privacy Shield framework to the new one. So that potentially is an advantage. There's another advantage too, though, because the court said that if you're transferring data to a third country which isn't in receipt of an EU adequacy decision, and the standard of the rule of law in that jurisdiction isn't essentially equivalent to that in the EU, then you will need to have additional safeguards in order to be able to transfer. So that's in addition to the standard contractual clauses. So you need both the standard contractual clauses and these additional safeguards if the country doesn't pass your mini adequacy assessment, or indeed if you decide not to bother with the mini adequacy assessment that the court talked about for that jurisdiction, and you simply assume, as I think is probably a pragmatic way of dealing with this, you assume that the country wouldn't pass this mini adequacy assessment and you put the additional safeguards in place. That's a less resource intensive policy to have. So you apply the standard contractual clauses and you apply the additional safeguards. Now, one of the advantages of continuing to be Privacy Shield certified is that you automatically have a few additional safeguards that you can use to supplement and complement your standard contractual clauses. So, for example, in Privacy Shield, you've got the arbitration mechanism for data subjects. You've got the assistance of the ombudsperson. You've got the review and sign-off by the DOC and also the assurance of FTC oversight. So in fact, continuing to be Privacy Shield certified is actually going to help you to be able to transfer data using the standard contractual clauses. And why else does it make sense to stick with Privacy Shield? Was, as I said, you may be able to transfer relatively quickly if you continue to be certified to Privacy Shield's successor instrument, as it were. And that will give, I think, your transfers a degree of stability. Not obviously perhaps as much stability as we would like, because obviously we've lost Safe Harbour a few years ago and now we've lost Privacy Shield as well. But there is a huge advantage, I think, to transferring on the basis of an adequacy decision, which is that under EU law, and this is slightly technical, the only authority that can declare EU law invalid is the Court of Justice of the European Union. So the only body that can say that an adequacy decision is no longer a transfer mechanism that you can use is the Court of Justice. And we know that it took 5 years from the Safe Harbour decision to the Privacy Shield decision. And that was all, I think, 5 years mostly being used in litigation. So it probably takes around 5 years for the Court of Justice to make that determination. So if we contrast that with what you're going to have under standard contractual clauses, and we know that the Court of Justice said in the Schrems II decision, the standard contractual clauses need to be closely monitored and policed by the supervisory authorities, and the supervisory authorities should suspend transfers where they consider that the essentially equivalent test isn't being met. That part of the judgment and that treatment of the standard contractual clauses makes them less reliable actually as a transfer mechanism, because they're subject to decisions, to suspensions potentially by the supervisory authorities. And so the adequacy decisions, by contrast, I think, do provide a level of stability given the fact that it's only the Court of Justice that can invalidate them as compared with the standard contractual clauses. So that's another reason why actually sticking with Privacy Shield may give you a slightly more stable transfer mechanism than standard contractual clauses. Now I'm going to hand back to Alex to talk a little bit more about Privacy Shield.
Thank you. So just a final couple of reasons. For certain organizations, Privacy Shield has really been the only viable transfer mechanism. A lot of our clients we have who are Privacy Shield certified provide services directly to individuals in the EU. And so there isn't really a suitable mechanism to get that data from the EU over to the US. It's frowned upon to ask individuals to sign up to standard contractual clauses. And there is some kind of fudge where you can often set up a local subsidiary and essentially sign clauses with yourself. But for a lot of these organizations, Privacy Shield was a really helpful mechanism because it enabled them to just glean data from the EU directly. And so for a lot of those clients, it's still, although the mechanism itself isn't valid, it still provides some reassurance that they're taking data protection seriously. It provides a good framework for, you're publicly committing to this compliance, and it gives a good, solid basis, largely on the lines of a lot of European principles. And just one more slide, Eleonor. Yeah, and then just don't forget, if you are deciding to leave Privacy Shield, because the court has invalidated it as a transfer mechanism from the EU, doesn't mean it's automatically finished, as we saw the quote from Wilbur Ross earlier. Essentially, you're still certified under Privacy Shield unless it comes to your annual recertification and you don't recertify, or unless you tell the Department of Commerce that you're withdrawing. And if you do, you have to fill out a withdrawal questionnaire, you have to appoint a contact person in case of any ongoing queries, and you either have to return all the data that you received under Privacy Shield, or you have to retain it and continue to protect it in line with the Privacy Shield principles. And additionally, if you're choosing that retention option, you need to send the Department of Commerce $200 a year for that. Not quite sure what it's for, but for the right to do that. But it's an additional payment and an additional bit of admin. It's $200 per mechanism. So if you sign up to the Swiss one, that's in addition. And you have to update them every year that you're still adhering to do that. So don't think that just because the ECJ said it's invalid as a transfer mechanism means all those obligations are completed, because there is this retention issue. And I think that's it, Eleanor, from me.
Thanks, Alex. So hopefully now you are in a position to explain to your colleagues what went wrong with Privacy Shield, but why it also makes sense from a strategic perspective with it. So that just about wraps up this session. This is us. So do get in touch if you've got any more queries about data transfers or data protection in general. And here are some links as well on this slide. So thanks very much for listening.
Thank you.